I ask you to please sit down and yield the floor to your opponent or back to the moderator, myself. You will have 2 minutes to respond and 1 minute for rebuttals as indicated by me. Not every question will have a rebuttal, but we'll try to keep it fair.
Can I remain standing?
Yes, Mr. Zavaleta has elected to stand. Mr. Villalobos, I believe, will sit for now, but we may see him stand in just a minute. At the end of the discussion, candidates are invited to make a brief closing statement as well. Let's begin with the introductions. Mr. Villalobos is seeking re-election to his second term as Cameron County District Attorney. He was first elected in 2004, defeating Yolanda de Leon, then moving on as the unopposed Democratic nominee. He's a graduate of San Benito High School, class of '86. He earned a BA in Economics from UT in Austin in 1990, and his law degree from Southern Methodist University School of Law in 1993. He has been a licensed attorney in the state of Texas since 1993, specializing in criminal law. Mr. Villalobos is married with 2 children. He's an alumnus of the National Hispanic Institute, a member of the Texas Association of County and District Attorneys, a member of the Board of Cameron County Child Advocacy Centers, and of the Democratic Party, among other distinguished affiliations. Welcome, Mr. Villalobos. It's also my pleasure to welcome Mr. Peter Zavaleta to our panel. Mr. Zavaleta is also seeking the Democratic nomination for this office. He's a graduate of St. Joseph Academy, class of '78. He graduated from UT in Austin in 1982 and earned his law degree from UT School of Law in 1985. He has been a licensed attorney in the state of Texas since 1986, specializing in litigation and personal injury law. Mr. Zavaleta is currently in private practice with the Zavaleta Law Firm in Brownsville. He's married with 4 children, is a member of the International Christian Center and the North Brownsville Rotary Club, among other distinguished affiliations. He's also a Brownsville Navigation District Commissioner, first elected in 2004, and served as the board's chairman from 2004 to 2006. Welcome, Mr. Zavaleta. Mr. Villalobos, may I invite you to make your opening statement, please?
Thank you. Good evening. This race is about experience in the criminal justice field. I've had experience for the past 14 years in the criminal justice field. 7 of those years as a prosecutor, 3 as the DA, and 4 as an assistant DA. I served as a public defender for the 357th Court, the 404th Court, trying cases all the way from Class C's to capital murders. There's not a criminal case that I can't try for you. Since I've been DA, we've made a concerted effort to rebuild that office. When I took it over 3 years ago, the problems were a high attorney turnover. They were losing cases they shouldn't lose, and there was not an open door policy. We've changed that. The turnover rate for our attorneys is very, very minimal. We win 99% of our cases, and we have an open door policy where any one of you can come and visit me, and a lot of you have. Since I've been DA, we've increased funding and support for a lot of vital positions. For example, we've increased funding and support for the Crime Victims Unit, a very important factor of our office. They're there to protect the victims and to make sure that they get the services they need. We've increased support for the CPS division and for the juvenile division. We've added more prosecutors, more investigators to make sure that we protect those most vulnerable, which are our kids. We've created new departments, the Domestic Violence Unit, which specializes just in domestic violence, prosecuting those that offend and hurt women. We've created a white-collar crime unit. That white-collar crime unit, approximately 50% of those cases have resulted in prison sentences and over $8.5 million in judgments against defendants that have ripped off honest business people in our community. We've participated in the Outer Crimes Task Force and the Environmental Crimes Unit. We've done our job. This is about experience, and I'm asking you to return me for an additional 4 years. Thank you.
Mr. Zavaleta?
Yes, good evening, and thank you for joining us tonight. I bring with you 3 reasons why I believe, with all due respect to the incumbent, that I am a much better choice to serve as your district attorney for the next 4 years. First, I am an effective lawyer. Second, I am a proven leader. And thirdly, I am a trusted public servant. This position is not who will be the chief felony prosecutor of Cameron County. This is a position about character and about experience and about leadership. And I believe that I am a clear choice in each one of those areas. I'm an effective lawyer, ladies and gentlemen. I have almost twice the experience as a lawyer that my opponent had in 2004 when he came before you and asked you to vote for him as district attorney. I've taken on numerous law firms. Usually in my cases, I'll have more than one defendant. I'll have more than one lawyer on the other side of my case. I'll have more than one law firm on the other side of my cases, and I have prevailed more often than not. I've also been rated by my colleagues here in Cameron County, both judges and lawyers, as having the highest ethical rating that any lawyer in the country can have. I also have been rated as having my legal skill is high to very high. My opponent has never rated on either his legal skill or his ethics. I have beat the district attorney's first assistant, Mr. Mattingly, in court. I have beat well-known criminal defense lawyers in court in criminal cases. Noe Garza, who contributed to my opponent's campaign, because he has a lot easier time with him as district attorney than he would ever have as me as district attorney. Joe Esquivel, who's board certified, a criminal defense lawyer who's an assistant United States attorney, I have beat him as well. I have been recognized nationally by Apple Computer and Microsoft. I was the subject of national feature stories on their websites for my use of technology in the courtroom. I'm not going to be able to go into detail as to how I am a proven leader, but my peers have chosen me all throughout my life, whether it's in my church, whether it's in my Rotary Club. In difficult times, I have kept people together. We have kept doing the business of the people that I serve. Thank you very much.
I was going to ask what qualifies each of you for the job, but I think we covered that pretty well, so I'll move on to my second question. And that is, for what aspect of this job do you have the least experience or training, and how will you overcome that? Mr. Zavaleta, we can start with you.
Yes. Actually, I don't believe that there's any area that I have the least amount of experience. As I mentioned in my opening statement, I have beat the chief felony prosecutor in the district attorney's office in a jury trial. I have beat well-known criminal defense lawyers in criminal cases before a jury in the past. I have proven in the last 3 years that I am an effective public leader. I was chairman of the Brownsville Navigation District. My fellow commissioners elected me to be chairman. That is a large organization. I have overseen that organization. I have overseen and managed a budget. I have inspired and worked with staff. These are all qualities that I will use as district attorney, because the position is more than simply being a prosecutor. It is about assembling a staff. It is about retaining a staff. It is about inspiring a staff. It is about leading. And I've proven that over the years that I am a capable leader. I'm also a public servant. I have learned to speak with the media, to keep them informed. Many times when my opponent is contacted by the media, there's no comment. And there should be, the public should be kept informed, as the case may allow, should be kept informed of the details of particular cases. He told us in May of 2007 that he would call a grand jury into the $21 million missing on a Brownsville Navigation District. He announced that publicly. He said that that grand jury term would run for 6 months. That term ended in November. There's been no response. I believe that was a political statement that he made. He made the political statement that a grand jury would be called. I believe it's incumbent on him to explain to us what has happened and what is the status of that investigation. So I believe that I am very well prepared as a lawyer for 21 years, as a father, as a husband, as a public servant, as a leader throughout my life in the different civic organizations that I have served. I believe that those experiences will prepare me well to be not only a good district attorney, but a great district attorney for the people of Cameron County.
Mr. Villalobos, if you could first respond to the original question, which is for what aspect of this job do you have the least experience or training, and how will you overcome that, and then I'll give you a chance to address the grand jury B&D question.
Okay. As far as the aspect of least qualified, I don't believe there is any least qualification for this office. I've proven it by running this office for the past 3 years. We have over 100 employees there. We have a budget of close to $6 million, actually. We have a over 99% conviction rate. So we've done a great job, so I don't think there's anything that we're lacking. As far as qualifications that I feel that are important, that are being overlooked here, is experience in criminal prosecution, not experience generally as an attorney. Anybody that's a lawyer can have that type of experience over 21 years, over 14 years, but experience as a criminal prosecutor. That's a different type of experience, and only I have that when you compare the two candidates. Our office, in order to make sure that you have high morale, in order to make sure that you hire the right kind of staff, you have to know exactly who you're hiring and what kind of qualifications they have, because you've done that job before. Not because they're telling you they can do the job, but because you can actually go into that courtroom, you can view them, you can converse with them, you can see how they're doing the job, you can correct them, you can actually move them to the side, step forward, and actually try the case yourself. That is what I bring to the table. That's what I've been doing for these past 3 years. Another very important factor here that he's brought up, and I would respectfully disagree with him, is that you cannot go out and tell the public what you're going to be doing, when you're going to do it, and how you're going to do it. That's not how it works in the criminal justice system. That may work in the civil system, but it does not work in the criminal justice system. You do not alert the criminals that you're going to come and arrest them. You do not alert them that you're going to investigate them. You do not alert anybody what the grand jury is doing. The grand jury is a secret body by law. Mr. Zavaleta knows that. He knows that you cannot talk about what goes on there. If you also look in the record, you'll see that the grand jury term has been extended by law, and so they are still working on the case. As to specifics, he knows that I can't talk about that, and I'm not going to violate the law by talking about issues that go on in the grand jury. That's a very, very important distinction between myself and my opponent. You have to have criminal experience, criminal prosecution experience to know what you're doing. Him talking about beating other lawyers in civil cases does not translate to criminal law. I'd put him up against Chuck any day of the week, and Chuck would kick his butt.
And you're referring to Mr. Chuck Mattingly, correct? There are a couple of follow-up questions on this, and then we can probably get back to the VND question which Mr. Zavaleta raised. A reader question on this topic asking, along the same themes, Mr. Zavaleta, what experience do you have in criminal law that makes you qualified to be district attorney? You've covered some ground on this. I'll give you a minute to rebut.
Well, as I said, we don't need to talk about hypotheticals with Mr. Mattingly and I. I already did what he said he would do to me. I actually did that. He can certainly rebut it if he believes that I'm not telling the truth. I've already done that. I've also...
In court, you mean?
Yes,
Okay.
well, I think that's what he was
Yes. Okay. Then moving back to the question regarding the Brownsville Navigation District. This is also a reader question. Well, let me start with my question, actually. Mr. Zavaleta, you've asked Mr. Villalobos to no bill or indict, those were your words, in the matter of the millions of dollars disputed between the Port of Brownsville and Downbound Engineering. You have filed a lawsuit against Downbound seeking to recover the money. What do you feel is the district attorney's role in recovering that money? What is it that you're criticizing Mr. Villalobos for not doing?
He made a very public statement, frankly, that was long overdue, because he subpoenaed our special counsel's report in January of 2005. And when I woke up one Saturday morning in March of 2007, and over 2 years later, and I read that he didn't have reason to even call a grand jury or subpoena a single witness, my response was the same as everyone else's response. You have got to be kidding me. After 2.5 years at looking into $21 million spent for a bridge that not even a spade of dirt has been turned, and our district attorney doesn't even have reason to call a grand jury, that is putting your gun in your holster and unloading it. That is the most powerful tool that a district attorney has at his disposal, is calling a grand jury and hearing from witnesses who are placed under oath where it's a crime in and of itself to testify falsely. And for him not to even consider using that is absolutely unconscionable. And it took Judge Carlos Cascos to send Mr. Villalobos a letter that the Herald reported that said, there may be an appearance of bias in the investigation process, and although I may not be familiar with all the details of the case, a perception exists, Judge Carlos Cascos said, that not enough is or has been done to resolve the many unanswered questions that still exist in the public's mind. March 9, 2007. After that article was published and after Judge Cascos sent that letter to District Attorney Villalobos, he suddenly felt that there was reason to call a grand jury. And he made a very public statement about that, in that same article, and he said, quote, "It's our intention to have an answer within this grand jury term." And he called the grand jury in May. That term expired in November. It would have been helpful for the grand jury or for Mr. Villalobos to have given a report as to what the status of that investigation was. I'm not saying to tell the bad guys what you're doing, but tell the public what you've been doing.
To what you can discuss regarding grand juries, but first, could you tell us what you believe the district attorney's role is in recovering this money, or in the quest to recover this money, and then as much as you can regarding the statements that Mr. Zavaleta has referenced?
Well, first I would disagree that with Mr. Zavaleta's statement that we've had this case for over 2 years or 3 years. Mr. Zavaleta's had the case since May of 2004. When he took office, he specifically told the Herald and us that he didn't want a criminal investigation in it. He wanted to pursue it civilly. He himself handpicked the attorneys that did the investigation and did the lawsuit. He himself. He kept these files from us for over 2 years. His own handpicked special counsel, Mr. Willett, who I respect, who I know very dearly, declared that there was no criminal activity in his report. That's what they handed to us. We subpoenaed the rest of the documents, but we have a report from somebody saying there's no criminal wrongdoing. They wanted us to hold back while they went after the money. I don't believe our office is here to be used for any particular person to try to strong-arm anybody into giving them money. We're not here to be using the grand jury system to extort anybody or to strong-arm anybody. For him to want us to do his job is a travesty. I don't believe that he has done his job. He's had the file for the past 3 years. He knows what's going on in that file. He knows the witnesses. He knows exactly what's going to occur and what didn't occur. If he felt that there was a criminal wrongdoing in 2004, he would have got then DA Yolanda De Leon on the horn, went down to her office and demanded they investigate, demanded they go out and interview witnesses, demanded that they go talk to Mr. B. He would have done that. He didn't do that. He waited until 2007 when he decides to show up, and after 6 months of not going to meetings, when he decides to show up and they vote on settling the case, when he's not happy with it, that's when he comes to my office and demands that we do something about it. At that point, we're faced with starting an investigation from scratch, because the one they sent us said there was no criminal wrongdoing. The grand jury has been investigating it. They've been doing a diligent job on it. They've been working many hours and many days during each month, and they're doing a good job for the citizens, and they're going to come back with a proper decision. But we're not going to do it based on what one individual wants or what a certain faction of the community wants. We're going to do the right thing.
Where's the money?
Thank you. You can submit your questions in writing.
May I rebut?
Just a minute. You said that your office's job was not to extort or strong-arm in the recovery of money. Do you believe that that is what the B&D and that is what this lawsuit is doing in trying to recover the millions of dollars?
I don't agree with the lawsuit because Mr. Zavaleta has put himself in the lawsuit as a party to get damages himself. So I don't believe that that type of lawsuit is what the public had in mind when he injected himself into the lawsuit. What I believe is that there was some mismanagement, extreme mismanagement by both the port commissioners, whoever they had in charge of the project, and the people they hired for the project. Now, when you want to criminalize something, I believe you have to have evidence to prove that. We can't just call a grand jury, indict people, show up to court, and just put Mr. Zavaleta on the stand and have him say, where's the money? You have to have evidence. Without evidence, you can't have
We don't know where the money is yet, do we?
I wish I did know.
Other than with Mr. Tannenbaum's firm, of course. And that's because, that's for two reasons, just to clarify. The board has not been able to exactly figure it out, and neither has the district attorney's office or this grand jury, which is still impaneled, correct?
That's correct.
Okay, thank you. Thank you both.
May I rebut?
Yes, you may.
Yes, thank you. I think that this exchange illustrates why Mr. Villalobos needs to be turned out of office. He views a grand jury as a means to protect his friends. I view a grand jury as a means to uncover the truth, ladies and gentlemen. Let me correct a statement that he made, and he knows better. I filed this lawsuit because he hadn't done anything. I filed this lawsuit. I'm donating my time. I am financing it myself. I am not asking for a dime's worth of damages. I am asking that the taxpayers recover the $2 million that Dannenbaum said the completion of their plans is worth. I understand that when you run for office, it's to serve. I don't believe that my opponent understands that. I believe that my opponent looks at this as a job. I look at this as a means of service. I want the taxpayers of the Brownsville Navigation District to no longer be exploited by a company that would charge them $15 million for a non-existent bridge. The outrage of that. I wish our district attorney, who has a staff of 100 people, investigators, the power of subpoena, the power to bring witnesses before it. I wish he shared the same passion for the people of Cameron County that I did. If he did, then perhaps we might be talking about convictions rather than not calling a grand jury. Thank you.
On the topic of the Dannenbaum case, a reader submitted a question to both candidates, and we'll let Mr. Villalobos begin. Do you believe that, and with all due respect to the senator, this reader asks, do you believe that Senator Eddie Lucio, who is a former Dannenbaum consultant, was involved with or has any responsibility with this disputed deal?
Well, I think that's for the grand jury to determine, Ms. Benavides, and it's unfortunate that if Mr. Villalobos had had his way, we would have never known the answer to that question. The fact of the matter is that Mr. Villalobos has been dragged kicking and screaming to this investigation. He never wanted to investigate Dannenbaum. He never wanted to call a grand jury. In fact, ladies and gentlemen, in January of 2006, Dannenbaum Engineering Corporation gave a $500 campaign contribution to Eddie Lucio III. 2 days later, Eddie Lucio III gave a $500 contribution to Mr. Villalobos. Now, I asked the people to follow the money. I asked the people to decide who is supporting whom. I asked the people to decide who is protecting whom. I am protecting the people of Cameron County. I am protecting the taxpayers of the Brownsville Navigation District. That is my special interest. I have received no money from Senator Lucio. I have received no money from Eddie Lucio III, and I will never receive any money from Dannenbaum Engineering. They want him to be the DA. I am your choice to be DA.
To you, but thank you for yielding the floor.
Okay.
Go ahead, please.
Those are ridiculous statements, even for Peter to state. That Eddie Lucio III gave me money that Dannenbaum gave him. I mean, that's ridiculous. I don't think Eddie Lucio has ever given me anything. I don't know the guy. 2006, he was running against my first assistant at that point, so he obviously wasn't very pleased with me, so I don't think that's very truthful.
And you're referring to, I'm sorry, State Representative Lucio?
That's correct.
The question mentioned Senator Lucio, just to clarify.
Okay. Well, he mentioned that I'm taking money from,
yes,
from State Rep Eddie Lucio III, who I now know, but in 2006, like I said, he was running against, or my first assistant was running against him, so to say that he was transferring money to me illicitly is a ridiculous statement. We've worked on this case diligently. The case was given to us in 2007. After the feds declined it several times, after a previous administration declined to get involved, now he wants me to be holding the bag for the money that he cannot find. The money that he can't even figure out how much it really is. First he says 21 million. If you look at the Herald articles, he goes down to 9 million. Then he goes down to 1.7 million. He doesn't even know, and he's been immersed in it. As you can tell, it's an obsession for him. He's been immersed in every fact, every detail, and he doesn't even know how much is missing or where it went. I have 16,000 cases that I deal with, ladies and gentlemen. 16,000. That means out of the handful that he's picked apart, the other 45,000 cases we seem to be doing a great job on, because the only ones he wants to pick on are 5 cases. We've done our job, and we've done it correctly, and I can't get into what the grand jury is doing, even though he wants me to, because that's illegal, and if he doesn't know that, he should know it by now.
Yes?
I will put Mr. Lucio's expenditure report, in which he donated $500 for Mr. Villalobos. I'll put that up on my website tonight, peterforda.com. The people can decide whether I'm making these facts up or not.
Thank you.
Peter for DA.
Mr. Villalobos, on the district attorney website, the county-sponsored website, you write on the homepage, "We in the district attorney's office are making every effort to achieve the lowest crime rate reasonably possible while emphasizing the prosecution of violent crime." What is the crime rate in Cameron County, and are you satisfied that it is the lowest reasonably possible?
The crime rate in Cameron County, it depends on what offense you're talking about. And it goes back.
Violent crime rate, if you could give us an estimation for the past,
Well,
let's say, 4 years.
The crime rate is in the 20s, actually. When you multiply all the different cities and you decide which particular field you're talking about, because the statistics deal with numerous types of crimes, and it's hard to get a grasp on exactly which crime rate you're talking about in the county. But what I mean by that is that when the police officers bring us a file, like I said, we deal with 16,000 cases. We deal with 50 police agencies. That means we deal with every type of diverse personality, every type of city agency, every type of federal agency. They all have different rules, they all have different regulations, they all submit cases differently. What we have to do is make sure that when they come in, we process them correctly and we prosecute them correctly. Now, when we prosecute them correctly, they get put on probation, they get sent to prison. That reduces the crime rate by taking that element out of circulation. That's our goal, and that's what we do every day. So that's what I mean by that statement.
And Mr. Zabaleta, should you become district attorney, how might you modify that mission statement, and how would you keep the focus on criminal prosecution, considering your specialty in litigation and civil matters?
Absolutely. First of all, Mr. Villalobos has woefully failed in prosecuting criminals. There are 2,000 cases right now in his intake section. Those are 2,000 victims who have been denied their day in court, their day of justice, and those are 2,000 criminals who are waiting to be sentenced. We will change that. And let me point specifically how we're going to do this. Mr. Villalobos has dipped into the Drug Forfeiture Task Force in the last 2.5 years to pay special prosecutors $354,000 in fees in the last 2.5 years. And let's be clear about that. When he wants to dismiss a charge against a political crony, he appoints a special prosecutor who in turn dismisses the charge against the political crony. Basically, what Mr. Villalobos is doing is he is using money seized by our law enforcement agencies from drug lords and using that money to protect his political cronies. I will do things entirely differently, ladies and gentlemen. I will hire the best, most ruthless, most tenacious prosecutors that we can attract and retain here in Cameron County. In addition to their base salary, I will work with Commissioner's Court and use the $354,000 that Mr. Villalobos uses to protect his cronies. I will use that to protect the people of Cameron County by bonusing the pay of assistant district attorneys based on their conviction rates. I have an open records request to Mr. Villalobos asking him to tell us what his conviction rate is for the cases for which he appoints special prosecutors. He refuses to give us that information. I will not use special prosecutors. I will use prosecutors who are special in ability, who are special in training, and we will attract them to Cameron County by giving them bonuses from the drug lords' money. I will use the drug lords' money to put more drug lords behind bars, not to protect political cronies.
In your rebuttal is the 2,000 cases currently in intake. What percentage of that of the cases that are being processed? And also, you have a golden opportunity to answer the open records request question without having to go through all of the FOI, but that's up to you.
Well, first of all, Peter doesn't know how to draft it properly. That's why it hasn't been answered, because he's asking too globally. What he's doing is trying to pretend like we're in a civil case and asking me interrogatories. That's not a proper request. Now, when he talks about the drug forfeiture fund and creating bonuses, that should be very, very offensive to attorneys out there and to the public out there, because Peter should read the code. The prosecutor's #1 job is to seek justice, not convictions. It's written in statute. That is our #1 function. That is what we live and die by. We do not seek convictions, we seek justice. He's ignoring that completely and saying we're going to base it all on money by going out and prosecuting people and convicting them no matter what the facts are. That should be very offensive to the public. Second of all, he's talking about apples and oranges. There is not $354,000 that we've spent on special prosecutors. If he reads it correctly, he'll see that those are contract attorneys that we have for our office that do Class Cs, that do mental hearings, that do different things for our office. Out of that money that he's identified, only about 173 of that is for special prosecutors. That 173 divided by 3 years, and you back out the taxes like anyone else, that's a special prosecutor working for $38,000 a year. I've done the community a great service by having people in this community that have awesome experience, more than 20 years as prosecutors, as defense attorneys, who work for the county for $38,000 a year. You can't find anybody who worked for the county for $38,000 a year in our courthouse as an attorney. We've done a tremendous job doing that. Using the DA's forfeiture fund, using grant positions, we save the county $2.4 million a year. He can try all he wants. Commissioner's Court won't give him another dime. We get 3.6 from Commissioner's Court. That's it. The other 2.4, we have to get it through other sources. We do a great job doing it, and we save the county every year $2.4 million to run that office that doesn't come from the local taxpayers.
Backing it up just a little bit, what percentage of the total cases processed are the 2,000 currently sitting at intake?
Those are all cases that need to be processed, and that includes juvenile cases, CPS cases, appellate cases, civil cases. We are a huge operation, Rachel. We are a huge operation. We have 100 employees. 2,000 cases a month is normal. We have cases that come in normally. They're all manual. The way it works and with the things that we're trying to do for the next 4 years is to automate that system. Right now in Cameron County, everything is paper generated. I cannot change it alone. I have to change 50 cities and agencies. The way they do it is they save them until they get badges so they can make a trip to Brownsville. You should have people in Harlingen, La Feria, Rio Hondo, Combs, Santa Maria, Santa Rosa, even from the island. They don't come when they get one case. They wait till they get 25, 50, 100. Then they bring it in batches. Having 2,000 cases is not a big deal. That's a normal day's work in the DA's office. We process cases as fast as we can, but we can only put the ones in court that the judges will call. Maybe you got to run for judge so you can move the dockets faster.
And one more question on this topic, let me see if I can phrase it properly. What percentage of convictions is secured by the cases that are given to special prosecutors by your office?
They have a very high conviction rate. One of the problems we have, and one of the reasons that we can't give the information that people want on the spot, is our system is a 1970s DOS-based computer system. You can't run a query on it and ask them, give me all the cases that Mike Martinez has prosecuted, give me all the cases that Charles Mattingly has prosecuted, so that you can run statistics. Our computer system is so outdated and inadequate that we can't get anything done when we come to statistics. We have to manually write out statistics. If he gives me a list of cases he wants information on, I'll be more than happy to do that. But our special prosecutors, they do the job. They do the job correctly. And one thing I'd like to correct also is that the judges appoint those special prosecutors, and they're actually called attorneys pro tem. Special prosecutors that I hire directly that work for me, those are more contract labor, and that's no different than just any other attorney who works for our office.
May I rebut?
Yes, please.
You know, it's really amazing, ladies and gentlemen, when Mr. Villalobos wants to brag about his alleged conviction rate as a staff, he has no problem coming up with a 99% conviction rate. A figure, by the way, which he refuses to substantiate in hard numbers. But yet, when I'm asking him very simply for the conviction rate of those smaller set of cases handled by special prosecutors appointed under his watch, he comes up with computerized gibberish about why he can't produce that information. I think the fact of the matter is, ladies and gentlemen, we can go back and look at the number of cases of cronies of this district attorney. He won't do it himself. He gets other political cronies to do it for him. Mr. Villalobos' system is good to his friends, but bad for Cameron County.
cases we prosecuted. We prosecuted Doug Wright, who I knew very well before I took office. We prosecuted Frank Puente, who was a sitting commissioner, who was a supporter of mine. We prosecuted Commissioner Rick Longoria's brother. We have prosecuted anybody that comes across our desk. When we deal with special prosecutors, it's because we have an inherent conflict that either we see or we feel the public sees. So to say that I let people go is a ridiculous statement. That's certainly not true.
You mentioned Commissioner Frank Puente in Harlingen, and I believe that the charge against him was DWI. Your office prosecuted him, but recused itself from the Charlie Atkinson DWI case, which City Commissioner, City of Brownsville, within Cameron County. Why prosecute Puente and not Atkinson?
With the City of Brownsville, we have a different relationship than we do with the City of Harlingen, and I think it's because the county seat is here in Brownsville. The City of Brownsville has over 400 officers. They have specialized units, and in my opinion, are the jewel of Cameron County when it comes to police force, because they have all the different systems, all the different resources for it. With the City of Brownsville, we have created interlocal agreements that have to be ratified by Commissioners Court. We do not have the same type of relationship with the City of Harlingen and their police force. When we go out and do special undercover operations, we seek the assistance of Brownsville PD. Because of that, and because of the current makeup and the current explosiveness of this City Commission, we did not want to inject our office and possibly harm our office in these interlocal agreements by becoming involved in a political melee, especially because candidates like this will not let that issue be whether it's DWI or not. It's going to be about who the defendant is. And that's a contradiction in itself. He's saying we should treat everybody equally, but he's singling out people and treating them differently. Our office, in order to give Mr. Atkinson a fair trial and to give our office a fair trial when we come into this particular venue and ask for funding and ask for resources, that somebody won't hold that against us, so we can continue doing the job for the community that we're supposed to be doing.
The answer is actually a lot simpler than that. Mr. Atkinson supports Mr. Villalobos, has given him a party, has contributed to his campaign. Mr. Puente does not support Mr. Villalobos, and therefore he got prosecuted. That is the simple truth. As a matter of fact, the Brownsville Herald put it better than I could when they wrote in January of '05, when Mr. Villalobos, who just had been elected and took office, would not prosecute the then sheriff, former sheriff Conrado Cantu. This is what the Brownsville Herald wrote. Quote, "We should not have to deal with a district attorney who is so involved in partisan game playing that he must step aside when certain cases are presented to him. All county residents should be able to have confidence that the people handling their cases in our courts can do so fairly and treat everyone equally, regardless of social status or political affiliation. It is this kind of cronyism," the Herald wrote, "that keeps this county mired in inefficient, wasteful, and corrupt government. As I said before, in the last 3 years, Mr. Villalobos has created 2 systems of justice in Cameron County, one for all of you and one for his friends. Mr. Villalobos is bad for Cameron County and good for his friends. The only difference between Charlie Atkinson and Frank Puente is Charlie Atkinson supports Armando, has contributed to his campaign, had a party for him, and Frank Puente did not. That is wrong, ladies and gentlemen."
That is a totally inaccurate statement. Totally inaccurate. Frank Puente and his mother walked with us when we ran against Yolanda de Leon. For him to say that he did not support me at the time is completely false. He should call Frank and ask him himself. We do the correct job. When we get into situations that call for a special prosecutor, we feel the best thing to do is to have them look at the case and prosecute them. I have thousands of cases from former clients that the law says that I could if I wanted to, but it's a disadvantage to that client who I've served before, who I know everything about that client, to then use that information unfairly against that former client. That's why special prosecutors are there. That's why the code says it's to seek justice, not convictions. He needs to understand that in order to be district attorney.
Is Mr. Atkinson a supporter of your campaign, and did he throw a party for you?
Mr. Atkinson, I believe, is a supporter of mine. He's
Go ahead, Mr. Villalobos.
I believe every city commissioner is as well. All of them have pledged their support.
I'm sorry, I meant a financial supporter.
He has not given me any money. He was a host of a party that someone else paid for, but he was not the actual financial contributor or anything to our campaign.
Thank you. Let's move on. Still on the subject of convictions, but let's talk about the Tracy Brody case. And the Tracy Brody case, in which the DA's office won a murder conviction from the jury, but then saw Mrs. Brody set free with a sentence of probation and a fine. This question comes from a reader. Mr. Zabaleta, you have implied that the result of the Brody case would have been different had you been the one trying it. What significant cases have you won in a jury trial in the last 5 years?
You know, in 2007, I represented a gentleman that had his truck stolen from him by his former business partner. And we won the truck back from him because his business partner was scamming him and making up documents. There have been other cases as well, Rachel. You know, the great failing in the Tracy Brody case was the fact that Mr. Villalobos never thought it important enough to show up during the trial. He was on the second floor, excuse me, and this case was being tried on the 3rd floor. And there was a 3-week-long murder trial, a high-profile case where a woman was accused of murdering her husband in cold blood at point-blank range while he slept. And he sent another team to try the case besides him. And I understand that sometimes you have to rely on your staff. But I think it's important that the jury understand that it's important enough for the district attorney himself to actually be in the courtroom. Especially, ladies and gentlemen, when after the conviction was obtained, her lawyer was asking for probation. Why didn't Mr. Villalobos show up when her lawyer was asking for probation? Why didn't he show up and tell the jury in closing statement or in the rebuttal of the closing statement? It's important in Cameron County that if you kill, you do serve jail time. I think that is absolutely inexcusable. I wonder whether it had anything to do with the fact that several weeks before that trial began, Tracy Brody's lawyer wrote a large campaign contribution to Mr. Villalobos. Did that have to do with him being sidelined in the case? That's something that only he can answer. But had I been district attorney, I and my staff both would have been present throughout the entire trial. What more important job do we have than making sure that a murderer is not only convicted, but receives the proper sentence?
Mr. Villalobos, please.
In the Tracy Brody case, it is a very important case. It's one that I personally worked on for a year. I assigned different trial attorneys to different cases. At the same time, we had the Mexican Mafia trial getting ready to go at 197. I visited with Chuck and the trial team every day after trial in the grand jury room preparing for the next day. I went into the courtroom. I did not see Mr. Zabaleta there every day. I went in there during jury selection. I looked at the jurors that they were looking at. So where he's claiming that I wasn't involved, I don't know. As far as because an attorney made a donation to me, it's curious. It's the same attorney that bonded him out when he got arrested and indicted. And Peters and his fathers. And now he's saying that all of a sudden that attorney is so afraid of me that he's going to pay me money so I won't show up. That's a ridiculous statement. On these cases, the jury has to decide the punishment. What we can do is present the evidence. We can present it in the best light possible, and the jury has to decide what the sentence will be. Now, I wanted to bring up the fact that he stated that our stats are unfounded. You can look those up on Aurora de la Garza's website. That's how we get statistics. They come to us in gross amount. They are not separated by trial attorney. If you were to look at them and see how they're being produced, you'll see that we can't separate them by special prosecutor or by prosecutor. They're given to us whole. They're given to us by court. That's how we come up with our conviction rate. As far as sentences, we have tried our best to increase sentences. For the first time in the history of Cameron County, we had a triple consecutive life sentence on intoxication manslaughter. That's never happened in Cameron County. We have done our work to inch up the cases. We can't take credit for every sentence. We can't. I understand that. But our job is to slowly, through educating the jury system, through educating the public, is increase those sentences. And I think we've done that job in 4 more years. We'll continue to do that job.
You had your chance.
Let's talk about another high-profile case involving your office, the Emmett Livingston case. This goes to the subject of objections. Mr. Zavaleta has criticized you for not raising an objection during sentencing of confessed killer Emmett Livingston. Mr. Livingston killed an Edinburgh teacher and her body was found on South Padre Island. He was convicted and sentenced to serve 23 years for the crime. However, Judge Abel Lemus allowed him to take 60 days to get his affairs in order before surrendering to authorities. In that time, we know he's disappeared. You have indicated that you objected privately to letting him go without bond, but why did you not publicly object to this ruling?
The Livingston case was not that one day. The Livingston case was more than a year long in the making. The Livingston case, we spent enormous resources and personnel prosecuting that case to come up with the conviction that we came up with. The sentence that we came up with as well, that we recommended. During that process, originally Emmett was given, I believe, like a $2 million bond. One judge who heard it, it's not the same judge who heard it at the end, had a hearing on it. We fought it tooth and nail, and he lowered the bond to $500,000. During the pendency of the trial, numerous hearings were held that we asked that his bond be revoked and he'd be put in jail. Each time we were told no. That was the second judge. It was finally turned over to the third judge who actually heard the case. And in that matter, he, seeing the record, seeing our numerous objections, we knew what was going to occur when we went back there. We went into the judge's chambers, and this was over a 2-day period. That's the other thing that he fails to realize. I was there the entire first day when we thought we were going to go to trial. That first day, the judge ordered us to work it out because we were close. We worked it out. We voiced our opinion as to whether or not he was going to be taken into custody right on the spot. The next day is when we came back to do the actual plea. I had another matter since that case resolved itself. I was in another court dealing with another matter. I wasn't out starting the car for a minute or doing anything along those sorts that he's trying to insinuate. What we were doing is doing our job. Anybody who practices criminal law knows that the court determines whether or not to revoke somebody's bond or when to take them in custody. We didn't go in there and do it publicly because we had made our point made with the judge numerous times over numerous hearings. That would not have made a difference. Peter knows that, and any veteran criminal defense attorney knows that.
What's your office doing now to secure the arrest, the rearrest of this killer?
We are working very diligently on it. We have several leads that we've tracked down. We have arrested and charged numerous people that assisted in his fleeing the jurisdiction. We were very close, but I can't reveal where because then he'll probably leave from that particular spot.
May I respond?
Yes, please. You have 1 minute.
Mr. Villalobos, you were far more concerned about slipping $200,000 to your former law partner than you were about protecting the people of Cameron County. That's exactly what happened. Your involvement in this case was limited to recommending to the husband of the victim, your former law partner, who banked $200,000 of a killer's money for not even a day's worth of work. When you allowed that to happen, Mr. Villalobos, you reduced the bond of a killer from $500,000 to zero. That is unconscionable. If any attorney in my office had even remotely participated in a plot like that, they would have not only been fired, they would have been reported to the state bar immediately. The sole purpose of the prosecutor in that case is to secure a conviction and to make sure that the accused is behind bars. It is not the job of the prosecutor to farm off the case to his former law partner, who in turn makes a campaign contribution to your account. The fact of the matter is, ladies and gentlemen, that after Mr. Livingston absconded, the family of Mr. Livingston sued Cameron County, you and me, in a federal civil rights lawsuit that is still pending in federal district court here in Brownsville. In that lawsuit, which Mr. Villalobos was a named party, and Mr. Mattingly is also a named party, along with Cameron County, the reason that Mr. Villalobos did not object was because that was the agreement. The lawsuit reflects that the district attorney agreed to let him have a 60-day head start. And frankly, on Wednesday of this week is the one-year anniversary of one of the biggest travesties and injustice that ever occurred in Cameron County. When Mr. Villalobos was missing in action, when no one from his office would stand there and stand up for the people of Cameron County and object when a killer was given a 60-day head start. Unconscionable, ladies and gentlemen.
We did not refer any case to anyone. That case was picked up and that case was filed against Mr. Livingston way before we worked out that deal where he was pled and before the judge let him go that day. Mr. Lucio filed suit many months before, worked on that case, worked out whatever settlement he did with the defendant's attorneys. We had nothing to do with that case, and that donation had nothing to do with that money. I don't know how much Eddie made. I've never asked him. If Peter's talked to him, then maybe he can enlighten everybody with that. Eddie has been a friend of mine for a long time.
And to clarify, this is not Senator Lucio or State Representative Lucio. This is a local attorney also named Eddie Lucio, a popular name in Brownsville, apparently.
That's correct.
Go ahead.
I did not have an opponent in March of March of 07. There was no need to work out any deals for campaign contributions. That's a ridiculous statement in and of itself. We did not agree to release anybody. The record is clear on that. It says this is not part of the plea bargain, Judge. That's in the transcript. The lawsuit he's talking about has been dismissed against me and Cameron County. That lawsuit is not pending against me. I did nothing wrong in this case. We did not agree to let him go. We argued about it for over a year. He was let go by the court, and we're trying our hardest to bring him back.
Why was he let go by the court, do you know? What was the reasoning behind that?
It's within the judge's discretion. We cannot ask the judge to explain himself why he's going to let somebody go or what he's going to do or why he's doing what he's doing. That's his discretion, and we have no right to ask him that.
May I respond?
Yes, keep it brief, please.
My opponent talks about his experience, but apparently it's ineffective when it comes to actually stopping a killer from walking out of the courtroom. As far as his denial that he had a hand in recommending his former law partner, we have the sworn affidavit on our website of the mother of the mother of the victim, and here's what she said. She says, I asked Mr. Villalobos the name of the lawyer he had recommended to Mario Hernandez, the husband of my slain daughter, Edmila. Mr. Villalobos did not deny recommending a lawyer to Mario Hernandez, but did turn red, then white, when I asked him that question, and would not answer it. I asked him the question again, and he refused to answer it. The affidavit goes on to say that Mr. Villalobos' secretary called Ms. Garcia back and said that in fact the lawyer recommended was Eddie Lucio. It was Eddie Lucio, no relation, that was Mr. Villalobos' former law partner in Houston, in Dallas. It was Mr. Lucio that, along with Mr. Villalobos, allowed this killer to walk out of the courtroom a free man and bank $200,000 of a killer's money.
That's an incorrect statement. The mother of the victim was in a fight with the husband of the victim. The mother of the victim wanted us to prosecute the husband of the victim because she felt that he had a part in her murder. We refused to prosecute the husband of the victim because there was absolutely no evidence tying him to the murder. We had our culprit and we had our conviction on that case. She was very upset, as anybody would be when they lose a daughter, and she lost control in our grand jury room and started, in my opinion, hexing myself, my family, and anybody in our office. It was at that point that we had her removed from our office. It had nothing to do with the conversations with Mr. Lucio or the civil case or anything along those lines. She was very distraught, very upset, and she wanted the widow to be prosecuted, which we refused to do because there's no evidence, absolutely none, to support that. Again, I did not release Mr. Livingston. That was done by the court.
May I respond?
Let's let Mr. Villalobos respond, please. I'm sorry, Mr. Zavaleta, respond, please. 15 seconds.
What a disgrace to blame the mother of a woman for her outrage over the loss of her daughter.
The disgrace is using her for political purposes. That's the disgrace. That's the disgrace. Using the word.
Let's move on to a topic from one of our readers on fiscal responsibility. Fiscal responsibility is necessary when running an office funded by taxpayers. I think we can all agree. The question is, has either candidate ever declared bankruptcy? If so, how was it handled? And just so you know, the Herald did spend much of today looking up records to try to substantiate this question. We were not able to, but we're asking it anyway since the readers did submit. Have either of you gentlemen ever declared bankruptcy?
No. Yes, I have.
How was it handled?
This was in 1997 when I had a lawsuit with my former employer, the one that Mr. Zavaleta has been making hay about this morning, and today's Brownsville Herald. Back in 1997 when I worked for a civil law firm, I worked as a civil lawyer and a criminal lawyer. They hired me because of my Spanish-speaking abilities to handle the Hispanic population there in Dallas. What they wanted me to do was to settle cases for the Hispanic populace at a much lesser amount than the Anglo populace. I disagreed with that. I started referring cases out. I broke the rules by not being faithful to my employer. Because of that, I was sanctioned and I was grieved, and because I wanted to return that lawsuit to the Valley, I went and sought counsel by an attorney who recommended that I file bankruptcy and have the matter moved down here to Cameron County, which I did, which we tried, which they found that the rules applied to the employer as well as to the clients. They gave me a sanction, I accepted it, and I moved on. The important thing to realize is that while this was occurring, my former employer, Ms. De Leon at the time, stood behind me, actually quoted to the paper that it did not affect, in her opinion, my ethics in the office. I was supported by Mr. Zavaleta, who knew full and well that that had happened in 2004. As a matter of fact, his father even donated to my campaign, and all the way up until he announced in October of last year, he had been a supporter of our office. So to say that that's an issue now, I think is a complete misstatement and misjudgment.
May I respond?
Yes, just one minute. I do want to add that the Herald has researched the state bar records for each candidate. In the last 10 years, this is the only sanction listed for Mr. Villalobos, and Mr. Zavaleta has no listed sanctions with the state bar in the last 10 years. However, there was the question of the arrest and indictment, which we'll get to in just a minute. You can go ahead and please respond.
As a matter of fact, although Yolanda De Leon did retain Mr. Villalobos as a staff attorney, she took him off the court rotation after he had been found guilty by a Cameron County jury of deceit, fraud, misrepresentation, and had his license suspended for a year, and after he was found by a Cameron County jury to have not safeguarded client property. He was taken out of the court rotation. He was assigned a second chair in the drug court, and he was primarily responsible for juvenile prosecutions in San Benito at the Darrell Hester Juvenile Justice Center. So although she did retain him in his employment, in his desperate straits, she certainly demoted him, reassigned him, and gave him far less responsibilities than he had enjoyed up to that point.
That is incorrect. I remained a first-chair felony prosecutor after that event. I was not demoted to a second-chair drug court. We did not have a drug court when I was there in 2001. So there's no way I could have been moved to a drug court. And it really repeats, you really need to understand that this was not a criminal matter. I was not accused of stealing any money. I was never arrested for it. I was never indicted for it. I never had to pay anybody off to dismiss charges for it. This was a matter where I dealt with my former employer and my former employer. I didn't agree with what they were doing. They didn't agree with what I did. I faced the music and I moved on.
To be clear, the charges against Mr. Villalobos were that he did not inform his firm that he had taken a client outside of the firm, correct?
That I actually pushed clients out away from the firm.
And also that money was not put into a designated trust account, not that it was misspent, only that it was put into a non-designated trust account?
Right. The rules require that you have an IOLTA account. I had a general account that I cashed a check for a client on. They have a strict policy on that, which I learned at a very young age, but it did not involve any allegations of stealing anything or any allegations of criminal laundering.
Was your license suspended?
I was suspended for 3 days.
That's been established. Thank you.
Rachel, 20 seconds, please.
Sure, we're going to give Mr. Davis just a few seconds to reload his camera. Thank you. A couple of quick reminders. If you could please silence your cell phones if you have not had a chance to do that, take the time to do that now. And I would advise you folks that are enthusiastic about these candidates to applaud appropriately and keep your comments to yourself. If you have a question, please submit it in writing, but stop disrupting this proceeding. Thank you. I will respectfully remind the candidates to keep the time allotted. Ms. Maldonado will hold a 1 minute, a 30-second, a 15-second, and a stop. Don't make her yell. She will. Getting back on board with our questions. Thank you. One of the reader questions asks to both candidates, why must we get so nasty during these debates? I think that we've kept a pretty good respect for everyone here. But one of the things that I think has gotten a little nasty, and understandably so, and we'll get to the subject of the campaign ads, which have been running in the Brownsville Herald and other publications online and otherwise. In these ads, each of you have questioned the other's integrity, honesty, and character in various forms. I'll bring the first up, Mr. Zabaleta, a DA report card in which you note your opponent's state bar sanction, which we just discussed. Mr. Villalobos, you counter with the arrest and indictment of Mr. Zabaleta. This was in 1988. Although Mr. Zabaleta does not have any disciplinary action from the bar, he was charged with 2 counts of misapplications of fiduciary funds, which means that he was accused of depositing a client's money into his office's operating account. Later, the complainant submitted an affidavit advising the court they would not testify against him in the case, which was later dismissed. Those are the basic facts of the case. We have heard Mr. Zabaleta's account of the event, and the Herald is researching the matter. I'd ask you to please summarize your position on this again for us.
Well, she actually said a lot more than what you just quoted, Rachel. She actually said, and I'm going to quote from her affidavit from March 10th of 1989, quote, "I have not been offered anything to induce me to execute this affidavit, nor have there been any threats of harm, and I am executing this affidavit of non-prosecution of my own free will." It was based on that affidavit that Ed Siganowicz, who was at that time a felony prosecutor, asked Judge Hester in open court to dismiss the charges against me based on the affidavit of the complainant. Just by way of brief background, ladies and gentlemen, I represented a gentleman in a divorce proceeding. The complainant was the disgruntled ex-wife of my client, who was serving as her own lawyer in that proceeding. She was not happy with the property division in the case, with the community property division in this case. And she persisted in making people think that I had somehow or another secreted community assets from her, or had worse, taken them from her, which ended up proving to be false. Not only was I accused of that charge, Ms. Benavides, I was absolved of that charge, and the charge was dismissed. By contrast, Mr. Villalobos has had in his employment an individual by the name of Justin Ramos, who had 2 felony possession of marijuana charges before working for Mr. Villalobos. He had been arrested 7 times between 1994 and 1999 for crimes ranging from criminal trespass to 3rd-degree felony possession of marijuana. In addition, one of Mr. Villalobos' assistant district attorneys, Carlos Masso, his nephew has a felony conviction, and his arcade remains open. Mr. Villalobos, let's get tough on crime across the board, not just make accusations about political enemies.
contacted today, do you feel that the original complainants in that case would continue to corroborate your account?
Yes, she testified to that under oath, and she stated very clearly that she had not been offered anything to induce her to execute this affidavit, nor have there been any threats of harm. Absolutely.
And Mr. Villalobos, your ads suggest that you feel there may be something more to this case. What are you implying in your ads?
Well, Rachel, as an experienced attorney in the criminal justice system, including prosecution and defense, I know perfectly well that you don't get indicted by accident. You don't get indicted by mistake. You get indicted when there's evidence to show otherwise. The same file that he's referring to has evidence in there of the actual accounts. So that means the DA's office, back in 1988, subpoenaed the bank accounts. Based on the checks that were written, decided to seek an indictment. A grand jury, viewing that same evidence, sought an indictment, returned an indictment. He was subsequently arrested. The reason I find this very, very important to the community is because his number one point is justice without politics. He's making it seem like what he's accusing me of is that people can come in and buy their way out of things. What did he do in 1988? That's exactly what he did. He's bought his way out of a criminal case. I bet you if you contact that lady and you ask her, she's going to tell you that she received money to sign that non-prosecution affidavit. You don't just get cases dismissed out of the blue. Something has to occur. I think it's important that the public understand that and realize that. Another very important factor is that the case has not been expunged. Since 1988, it has not been expunged, because the only time you can get it expunged is when you're innocent of the crime. No other reason. And he knows that if he tries to get it expunged, that whoever's the DA at the time he tries is going to go in there and say, Judge, look at all this evidence. He committed the crime, do not expunge this offense. That's why that thing still shows up 20 years later, despite his claims and assertions to this. He committed the offense. The public should be aware of that. It's a big difference between a criminal action and a civil action, and that's the difference here. And the public should be very aware of that.
Did I understand you to say that you believe that the complainant in this case, do I understand you to say that you believe the complainant in this case was paid to turn in that affidavit?
I believe so.
If that's the case, and you being the district attorney, is there some action that you plan to take on this?
When there's a criminal case involving children, and this case involved children, it was a trust account for children. Money that was misspent out of a trust account for kids. When you have kids, you wait till they're 18 before the statute of limitation runs. My understanding is those children recently turned the age of majority, so if the statute is still relevant, then that's B1 that we could send to the special prosecutors he complains about, because obviously I would have an extreme bias against Mr. Zabaleta and would be unfair to him.
To respond, I definitely will. Someone in the audience shouted out, do you have proof? Do you have proof?
I have had contact from an investigator on the case back in 1988, a retired district attorney's investigator who has indicated to me that she was paid off.
May I respond?
Yes, please.
This is why I ran the ad today, ladies and gentlemen, that I ran, because of the scurrilous attack like this. I will put my reputation and my family's reputation behind my statements. I have a clean criminal record. I am not a crook. It is Mr. Villalobos who has been found guilty by a Cameron County jury of deceit, dishonesty, misrepresentation, failing to safeguard their client's money. And it is Mr. Villalobos who has the audacity to question my character when he himself had his license suspended for professional misconduct. I find that highly offensive. I have, and the court had before it, to suggest that Judge Hester, who was the toughest judge of all, would be a party to anything remotely what Mr. Villalobos is suggesting is an insult to the good name of Judge Hester and the many lawyers that regard him as a mentor. I also want to ask Mr. Villalobos to explain to us the deal he cut with Conrado Cantu when he dismissed the indictment against him. By his own words, if an indictment is dismissed, somebody was paid off and a deal was made. Mr. Villalobos, what was the deal that you made with Conrado Cantu? What was the deal that you made with Leonardo Garza, Conrado Cantu's buddy, who pointed a gun at sheriff's deputies and threatened to kill them, and you dismissed the charges against them. What was the deal that you made against them, Mr. Villalobos? By your own words, what was the deal that you made with Roy De Los Santos Jr., who was arrested for public intoxication for falling asleep outside his apartment complex while smoking a cigarette? You dismissed the charge against him. Mr. Villalobos, what was the deal that you made with Sandra Garcia? She was arrested in June of 2004 for 2 counts of deadly conduct. You dismissed charges against her in June of 2006. What was the deal that you made with Sandra Garcia? She was arrested again in August of 2005. You dismissed that charge against her in July of 2006. The only one playing Let's Make a Deal here is Armando Villalobos.
Thank you, Mr. Zaleta.
Well, I'm not sure which cases he's referring to, but I did not dismiss anything in this district on 2. That case was submitted to another DA who handled that case. It actually stood stagnant since the DA before me. A lot of those offenses that he's referring to, the only one that I recall is the Garza case. That case involved using witnesses that were all in the federal penitentiary. That'd be a difficult case to prove if your witnesses are serving time. That's why that case was resolved. As far as we can put this matter to bed, I'll pay for a polygraph for both him and for the victim, and we'll see who's telling the truth. I believe that he paid her off, and I think in his heart he knows he paid her off.
Prove it.
And then we'll prove it. We'll let him take the polygraph. I'll pay for it myself.
May I
Why don't you
respond?
take one?
Briefly, ma'am, if you
May I
continue to
respond?
disrupt, I
Let-
will ask you to leave.
Let me refresh our district attorney's recollection on Conrado Cantu's dismissal. Less than a month into office, Mr. Villalobos' choice for special prosecutor was the famous Juan Angel Guerra, the district attorney from Willacy County. That was the guy that had chickens and goats outside of his office in the Willacy County Courthouse. That's his idea of a special prosecutor. And that special prosecutor is the one who dismissed the charge against Conrado Cantu. You did not object, Mr. Villalobos. You did not appeal. You did not refile an indictment charge. That is the dismissal that I'm talking about, Mr. Villalobos.
That case, if you would, first of all, as crazy as Juan is, he's a better prosecutor than Peter. Second of all, I didn't have jurisdiction on that case once it was recused, once I was recused, and I don't get to pick who the prosecutor is. The judge does. Second of all, I'm going to prosecute a guy who just got hammered with 24 years so I can put him for 6 months in our county jail. That makes absolutely no sense whatsoever. So think about judicial economy, think about how you use the powers of DA, and you need experience for that, ladies and gentlemen.
Thank you both. Thank you. There's another reader question. In the case of Hector de la Torre, a man with 17 convictions and 8 felony DWIs, the question is, why did the district attorney allow, without objection, for the court to reconsider the sentencing of this criminal and convicted felon? If he violated the conditions of his probation, shouldn't it be case closed? The reader also asked if there is any allegiance to defense attorneys, many of whom are contributors to Mr. Villalobos' campaign, including Ernesto Gomez with $5,000, who is the attorney for Mr. de la Torre, if he feels any pressure for quid pro quo. Two parts.
I'm sorry.
I'm sorry, there's 2 parts. 1, why didn't you object in the sentencing of this gentleman? And 2, if you feel pressure quid pro quo from defense attorneys.
We did object to the sentencing. If you pull the record, and I have, and I'll post it on any website you want, we objected very strenuously to him being reheard. This is a 2-part case. This is no different than Mr. Zavaleta's good friend, convicted felon Dan Reyna, who drives around in his car. He's convicted, he's sentenced, they come back for a rehearing, and at the rehearing, when we object anyway, they give him a brand new lease on life, they give him additional probation. That's from the judge. We fought that case, it's in the record, you can pull it, you can read it, I can give it to you. As far as the second part, What was the second part of the question?
If you feel any pressure
No, I
from
don't.
defense attorneys who contribute to your campaign.
No, because if you look at the attorneys that have donated, those are attorneys that if you go into the courtroom, they're trying cases against us. They're trying these cases, they're losing them. They know and they respect us. If we didn't have any cases tried against these people, or their clients were just walking free from our office, no charges filed absolutely at all, then you could make those type of allegations. But in this situation, those attorneys understand what it takes to run the DA's office. They're experienced attorneys. They deal with my staff every single day. They know you need an experienced person there. They know they need somebody with an even temperament. They know that they need somebody who's going to follow the rule of law, and number one, knows the rule of law. That's why they support me. That's why they endorse me, and that's why they give me their hard-earned money. I wish I didn't have to spend $150,000, $160,000 on a campaign, but I got to pay bills. I got to pay the Brownsville Herald $4,000 a week to run my ads. If you guys will let me do it for free,
It's great publicity. It's great publicity.
I have to pay all the TV stations for the commercials. This is the cost of doing business, and I am grateful that my peers respect me enough to donate to my campaign and support me. I don't think the same can be said for his peers.
To tailor that question for you, Mr. Zavaleta, do you or have you received campaign contributions from defense attorneys, or would you accept campaign contributions from defense attorneys?
I have actually, but nowhere near the concentration that my opponent has. 78% of his money comes from criminal lawyers within a 5-mile radius of the courthouse. Now, I ask you, ladies and gentlemen, how can Mr. Villalobos be tough on criminals when he is cozy with their lawyers? They are not paying because he's a handsome man or a nice man. They're paying because they're getting good deals at the DA's office. A good deal for their clients does not mean that it's good for Cameron County. They like things the way they are right now. They don't want me there because I will give them holy hell. I will stand for the people of Cameron County. We will not make deals and allow killers to walk out of the courthouse. We will not allow a man like Hector de la Torre, who had 8 DWI convictions, including 4 felony DWI convictions. I will not send a rookie prosecutor like Mr. Villalobos did to make token opposition to the request for probation. I will send the hardest-hitting, most senior prosecutor necessary to stop that travesty from happening. It's very easy for him to sit behind a desk and say it's the judge's fault. But ladies and gentlemen, he is the one that is running on his experience. Where has that experience gotten us? Where has that experience gotten us? It is ineffective experience. It is experience doing things the wrong way. I am not compromised by campaign contributions from criminal defense lawyers. My only interest is in representing the people of Cameron County. I don't care if criminal defense lawyers don't donate to my campaign. In fact, I regard that as a badge of honor. They don't want to see me in the courtroom. They like it a lot easier the way it is right now.
Campaign contributions from criminal and civil attorneys, attorneys that do not practice criminal law, attorneys that are his peers, that don't donate to him, they donate to me, that never step foot in the criminal courthouse. I have numerous contributions from doctors, from teachers, from lay people, significant amounts. So everybody is united in the fact that you need an experienced person in the DA's office, not somebody who's going to fly off the handle and start illegally using the grand jury or the law for his or her own benefit. A good example is where he says that he's not going to allow a defendant to walk out of that courtroom. He doesn't have a choice. If the judge says you're walking free on probation, what is Peter going to do? Tackle him and then get charged himself? You don't have a choice. You have to stand back and wait for the next case. I did not have a rookie lawyer there. Mr. Oscar Guzman is one of my finest attorneys who's been practicing for quite some time and could run circles around Mr. Zavaleta in the criminal justice field.
Politiqueras, a reader, someone in the audience has asked if given evidence and proof Will you prosecute politiqueras on mail-in fraud and abuse? Mr. Zavaleta.
Absolutely. I've already stated that publicly. We're not using politiqueras in our campaign. To suggest that someone who is of modest means, with modest clothing, who has my sign at a street corner is a politiquera is an insult to democracy. These are people who are volunteers in our campaign. These are people who are taking time away from their families to stand in the hot sun on street corners. We all know what politiqueras are. Politiqueras are people who are paid to steal votes from the unsuspecting and the elderly. The fact of the matter is, ladies and gentlemen, it is a huge problem in Cameron County. It is a problem that has only gotten bigger under my opponent's watch. It is a problem that he himself has done nothing to stem or prevent. If anyone thinks that Mr. Villalobos would ever prosecute a politiquera, Dannenbaum has a bridge at the port of Brownsville that they would love to sell you.
Prosecute any case where you bring evidence before us that's sufficient to go to court on, even if it's a politiquera. We don't hire politiqueras, we don't endorse that use. I disagree with Mr. Zavaleta. When you're in the political field, and I've only been in it 5 short years, you know who the politiqueras and politiqueros are. The public knows who they are, and all they have to do is look around and see them. When you go out and see us, you see my family, you see my friends. You don't see when we go pay somebody to stand on a corner and do it for me. You'll see that we'll do it ourselves.
Right.
Okay, thank you. Changing the subject a little bit, to your opening statement, Mr. Zavaleta, where you said that morale building and low turnover was important in a district attorney's office. I'd like to bring your attention to a letter to the Brownsville Herald dated January 30th, 2005. In part, you write, I'm impressed with the caliber of lawyers Armando Villalobos has been able to persuade to join him in the district attorney's office. Tough, seasoned courtroom warriors who most definitely will put the bad guys away, and that each would be willing to leave the autonomy of their own private practices to join Mr. Villalobos, speaks highly of him and his governing style. Keep up the good work, Mr. District Attorney, exclamation point. At what point did you change your mind about this district attorney?
As far as that letter is concerned, I stand behind that, Rachel. I sent that letter from my heart. Armando was nice enough to call me up after he received it, and he thanked me for it. The problem is, I think that letter was a little premature because all of those lawyers mentioned there didn't last longer than 6 months. So
and the lawyers mentioned in the letter, folks, are John Blaylock, Rebecca Rubain, Rene Gonzalez, and Veronica Farias, just for the record.
I believe that, first of all, I believe that Mr. Gonzalez is still employed by the district attorney's office. Ms. Farias never, in fact, worked there.
Okay.
She was rumored to have been recruited to work there, but I believe she never, in fact, worked there. That was a letter that I sent to Mr. Villalobos as a colleague and as chairman of the Brownsville Navigation District. From one public servant to another, you just took office, you're in the honeymoon period, you have the support of many people in Cameron County, and that letter was an expression of that from the heart. But what we've learned in the last several years is that lawyers have left his office. For whatever reason, they have left his office. And I think that part of the reason that that has happened, frankly, is because they're not being paid appropriately. And this goes back to my earlier plan about using drug lords' money not to hire my compadres who will in turn dismiss cases against my political cronies. I'm going to use that money from the Drug Forfeiture Task Force to incentivize our staff members, including our lawyers, so that we can retain and recruit the best caliber people. I think morale is very important. I think when you come to work in the morning and you're happy about the work that you're doing, you feel that it has a bigger purpose than simply a 9-to-5 job, then I think you get good results, and the people of Cameron County benefit from that. I believe that as a leader my entire life, in civic organizations, in my church, at the B&D, even on the football field as a young quarterback, I feel that I can inspire people to achieve great things in a teamwork atmosphere. And I think that's something that I can bring that my opponent just simply has not been able to do.
Just a couple of questions remaining before we make our closing statements. One, for both candidates, and I'll summarize to say that conditions at the Cameron County Jail are believed to be subpar, and some folks who are incarcerated, particularly women, may be waiting longer than they should for a court date. What do you plan to do to speed up the lag time? And I'll let Mr. Zavaleta begin.
Well, obviously we've got to work closely with the Sheriff's Department. I'm happy to have been endorsed by the Cameron County Sheriff's Deputies Association. They've observed Mr. Villalobos over 3 years, and they have found him severely lacking, that they have endorsed my candidacy for district attorney. I will work with the sheriff, whoever the voters of Cameron County elect to that position, whether it's Sheriff Lucio or someone else. I will work closely with them. I will make sure that accused are properly and appropriately and swiftly prosecuted, and that they receive the appropriate sentence.
Have you had a chance to tour the facilities? I'm sorry, I should have asked you that first.
No, I have not, Rachel. To be honest with you, I have not. But it is something that I want to do. I know that Gail Hansen, who has a wonderful heart for especially female prisoners, is a long-time friend of mine. I get emails from her regularly. I know that she is educating all of us about the deplorable conditions at the jail. I regard her as a friend. I taught on a volunteer basis at Valley Christian High School several years ago. She and Paul both are saints, in my opinion, and I look forward to working with Gail and the other authorities in making sure that the jail... Winston Churchill said that you can tell a society by the way it treats its prisoners, and I believe that very firmly. As a Christian, it's what you do unto the least of us that you do unto Christ himself. And so I believe that after the individual has been sentenced to prison, they should be treated humanely and with human dignity, because we are all endowed by our Creator with those inalienable rights.
Thank you. Mr. Villalobos. First, have you recently had a chance to tour the facilities?
Yes, I've toured the facilities. This is a good example of the difference between my opponent and I. He has absolutely no clue how to answer that question, so he has to go into an ad-lib. When you're dealing with an issue like that, the issue that we've been dealing with since I've taken office, remember, the important thing is that everything is turned in manually. We've been trying to change that since the very beginning, since I took office. In order to do that, you have to upgrade your computer system, which we're doing. You have to convince other law enforcement agencies to change the way they do business, which we're doing. The problem we have here are not inmates that are sentenced to go to prison. The problem we have here are the inmates that are waiting to go to court. Those inmates need to be processed faster. We've addressed that in one method by creating 2 new courts to speed up the process that these inmates are going to come to court in. The second thing that we can do is create the new intake system that we've been working on for 3 years. When you have an arrest, you have an automated system to send the file and the crime over to our office electronically so that we can process it, get it filed in court, and get that person into court quicker. That's going to make a difference. That's going to change the waiting time. That's going to change the amount of money we spend on 4 different jails. That's what's going to make a difference. And the only way to know that is if you've been in there in the trenches, if you worked as assistant DA, if you worked as a defense attorney going to see your client, if you worked as a DA managing this entire enterprise with all the different agencies, seeing what the problems are, seeing what the benefits are, studying other ways of doing business from Bexar County to El Paso County to Harris County, that's the only way you're going to know how to change things. We've been doing that slowly and surely, and like everyone else knows, it takes time to do that, and we're in the middle of changing this system.
Our last question is a reader question. It's from a young man named Ryan Villarreal, who is studying at Southern Methodist University. He writes, "My question is for both Mr. Villalobos and Mr. Zavaleta. I'm a 19-year-old public policy and international studies double major at SMU who graduated from Los Fresnos High School. I will go to law school immediately following my graduation and plan to one day be standing in your same situation this evening. As a teenager, I have always known my purpose is justice and politics. My question is this: what were you doing in your youth to plan for this day, and how will that fervor shape your future as the next or returning district attorney?" And I'll let Mr. Villalobos begin.
Well, in my youth, I participated greatly in academic endeavors with San Benito High School. I'm a San Benito graduate salutatorian, was involved in everything that you can think of. I participated in National Hispanic Institute, which is the LDZ program. Went out and learned politics as a young 14-year-old in the summer. That's where I met my lovely wife. I've been training for this job since I was a youth. I've always wanted to be DA. That's why I spent 4 years as an assistant DA. That's why I've learned the criminal justice system, the criminal code of procedure, the penal code. I enjoy this job. I love it. This is what I was born to do. I'm a prosecutor. I do it well. I've trained for it. I'm going to continue to practice it. I'm asking the community to return me there for an additional 4 years. I believe we've been doing an outstanding job, and we can continue to do an outstanding job.
I think it's a wonderful question, Ryan, and I thank you for that. I was an altar boy growing up, just in the shadows of St. Mary's Church, being prayed over by priests for my career. I was a student athlete in high school. Someone said that team sports don't reflect a person's character, they reveal a person's character. And my team and I, a team of 19 ragamuffins from Brownsville, Texas, the wild card entry our senior year in the state championship playoff, took a plane all the way to the Oklahoma border and beat an overmatched team, a team that frankly deserved to win the game, but out of sheer grit and determination, we pulled that victory out and brought a state championship home to Brownsville. I say that because I have been a part of a team, and I have led teams my entire life, as a Rotarian, as a deacon at church, as a father, as a husband, as a volunteer giving children polio shots on the weekends, as a volunteer at the Boys and Girls Club, giving children football uniforms so that they can play on Saturday mornings. That has been my life story. I have, ladies and gentlemen, a record of public service. I didn't decide to run for office so that I could serve. I served first, and then I ran for office as your public servant. I think you've seen tonight two different hearts, two different worldviews, two different visions. One who believes that our best days are in front of us, that this is a wonderful county, that our best days are in front of us, and one who believes, as we've heard tonight, that everything has a price, that everything is for sale, and that if you do good, there must be some ulterior motive behind that. We have a very clear choice between the past of Gilberto Hinojosa, Conrado Cantu, and Armando Villalobos, and the future of Peter Zabaleta and the people of Cameron County, Republicans, Democrats, and Independents. That's what I stand for.
Before we move to closing statements, I'd like to extend the opportunity to each of you, and you may take it or leave it, to take 30 seconds to say something positive about your opponent.
I'd be happy to go first.
Go ahead.
I think Mr. Villalobos is a very nice man. I did not support him when he ran in 2004. My father did support him. My father is a very generous man, and he liked this young man. This young man came to see my father when he was interviewing for the position of city attorney. I actually had the privilege to talk with him instead because my father was out of the office that day. I liked Armando. I think he's got a great future in front of him. I think he's had some difficulties along the way with the bar suspension, his bankruptcy, and some other issues that perhaps have held him back. But I think he's a very nice man, and it's very fun to be around.
Thank you. Mr. Villalobos.
I like his family. His family is very nice. His wife is very nice, and his children. And I like his family.
Mr. Zabaleta, would you like to make the closing statement first?
Sure, I'd love to. Is this 2 minutes?
Yes, this is 2 minutes.
Thank you. As I mentioned just a moment ago, ladies and gentlemen, it is my privilege to stand before you as your candidate for the Democratic nomination for District Attorney. And I'm asking that you join with me and Republicans, Democrats, and Independents in uniting behind my candidacy on March 4th. Some in the Democratic Party, a very small number, who want power back, want you to sit in the political corner this March and not speak until you're spoken to. I say this is your county. It is your vote, and it is your voice. What we have seen in the last 3 years, ladies and gentlemen, is Cameron County has been divided between you and I and working folks and Armando Villalobos' political cronies. They receive one form of justice, and we receive a far less form of justice. I'm running to take out the politics out of justice. This is an elected position, ladies and gentlemen, but it should not be and is not a political position. Something is either right or it is wrong. You can be assured as you are in the last 3 years that I have served you as your commissioner at the Brownsville Navigation District. When I stood up for you, when I stood up against all odds, when 4 commissioners would sell out the people of the Port of Brownsville and give a company that charged us $21 million, and on Thursday of this week is a 1-year anniversary of the greatest sellout in the history of Cameron County. We still don't have engineering plans. We still don't even have a progress report. I stood for you, ladies and gentlemen. I will always stand for you. You know my heart. You know my character. I am an effective lawyer. I am a proven leader. And I am your trusted public servant to be your next Cameron County District Attorney. Thank you.
Mr. Melvin, 2 minutes.
Thank you. I want to thank everybody for coming out, even those that from the jeering section. I appreciate that. That's part of the process. I take no offense to that. I believe that we do have clear differences here. I'm a prosecutor. I'm experienced in criminal trial. I don't have to go and learn the system. I don't have to go and be taught how to do my job. I can inspire my employees. I've done that over the past 3 years. You can go and ask them for yourselves, and they'll tell you. The boss is the guy that will show up, and he'll clean the bathrooms with us. The boss is the guy that will show up, and he'll go into the grand jury room and express a case. The boss is the guy that will show up, sit down and do paperwork. The boss is the guy that will show up and say, you're not doing it right, step aside and let me do it. I've been through every phase of that office. I started out at the very bottom, worked my way to the top. I don't have to have on-the-job training. We are not in dire straits like Mr. Zavaleta wants you to think that our office is in shambles. We have a very, very high success rate. We have many, many great people there. We have many great divisions there. We are going forward with these divisions, new divisions. We're on the cutting edge of technology in our office. We're increasing that little by little, but it takes somebody who can steer the ship and know all the different factors, know all the different policies, and all the different danger zones. You have that with me. I will continue to work on your behalf. I will continue to serve you and do the right job. Thank you.
Herald and myself, Rachel Benavides, Mr. Villalobos, Mr. Zavaleta, thank you so much for joining us tonight for this vigorous discussion.